For the record, will you please spell your state your name and spell your first and last name?
Perry Tarica, P-E-R-R-Y-T-A-R-I-C-A.
And Mr. Tarica, are you currently employed?
Yes,
In what capacity?
I am a financial consultant with A.G. Edwards and also on a part-time basis reserve police officer with Des Plaines, Illinois.
And how long have you been employed as a financial analyst?
I've been in the business 28 years, with A.G. Edwards 12 years.
And what sort of education and training do you have which qualifies you for a position in that field?
I have a degree, undergraduate degree in finance from DePaul University.
Now, at one point during your career, did you ever have occasion to work with a woman by the name of Julie Jensen?
Yes,
Do you remember when and where that was?
that was at Dean Witter. I was employed at Dean Witter in 1988, I believe.
And was Julie Jensen employed there in 1988, or was it some later time?
It was at a later time.
Okay, at some point, Julie Jensen became employed there too?
That is correct.
And when did she become an employee there?
I don't know the exact date, but the firm that she had worked at had gone belly up. So there was a group that Mr. David DeWar had brought over, and they started work at Dean Witter.
And what did Julie do when she came over there to work with you at that firm?
She was a sales assistant for Mr. Mike Hope.
And do you know what a sales assistant does?
Basically, pretty much anything that as far as the broker, as far as handling client calls, helping disperse checks, basically the right-hand assistant to a broker.
Well, is it a clerical position or something beyond a clerical position?
It's administratively, so it would be, mainly clerical.
So at some point, did you get to know Julie Jensen when she was employed with you there?
Yes, I did.
Tell the jury about how that relationship developed.
Julie had just had a child, and I had a little girl, and we were talking about children, and basically we just got to talking, and she could see that how I enjoyed children, and the conversations just grew from there. Basically, it was just talking in the beginning.
Were you married at that time?
I was going through a divorce.
Did you know whether Julie Jensen was married at that time?
Yes, I did.
So at some point, the relationship that you had with Julie Jensen turned into something more than just a friendship at the office. Is that true?
Yes.
Tell the jury the process about how that occurred.
Well, we were talking, and it was a lot of talking. We exchanged views. We it was just being a friend to her. She had said she was extremely unhappy in her marriage. She doted on her son David. She was very proud of him.
Did she tell you why she was unhappy in her marriage?
Well, during the course of the relationship, she had said that Mark was weird and strange. She had said he didn't spend much time with his son, although he was a newborn. But the short time that I had known and even seen her son, she had said that I had paid more attention to him than his father. Could you repeat so I could?
Well, so at some point, did you start to have feelings for Julie Jensen?
Yes, I did.
Tell us about the feelings that you're starting to have for Julie Jensen.
Well, Julie, in my eyes, was very. She was a simple, sweet, kind, and a passive person. She wasn't flamboyant. She was a good mom, from what I could see. She cared about her son David very much. Everybody spoke well of her, okay, at the office. These were people that had worked with her for years. They spoke very well. And there was never a vulgar or unkind word out of her mouth.
Judge, I object to continuing in this line.
Move on to something else, Mr. Jensen.
Well, we'll get back to this question. Mr. Tarica, describe, if you will, how your feelings about Julie were developing at that point, and how you ended up feeling about Julie.
Well, I guess going back to, she was a very kind person. She showed me.
No, the question is, how did your feelings develop, not how you perceived her?
How did you feel about her?
I object to continuing.
That's not, no. What happened in the course of the relationship, not how you felt about her, but what developed in the course of the relationship?
Oh, okay. We basically had lunch together. At times, I would, if we could, we would, before work or maybe after work, we would talk. That's basically how it developed. She had, we would, if we got an opportunity, we would meet.
Outside of work you would meet?
Mainly it was at work, maybe in the parking lot, we would talk. We had met a couple times from my recollection outside of the work environment. She had once come to my apartment. And I had once, I was going to see my divorce attorney, and she came with to talk to him.
Now, at any time, did you ever have sexual relations with Julie Jensen?
Yes, it was one weekend. Mark Jensen was out of town, and she had invited me up. And
Invited you up to where?
her home.
And did you go to her home?
Yes.
And when you went to the home, what were you expecting was going to occur, if anything?
Actually, nothing really, other than to spend time with her. Her son was there. I played with her son. We had dinner.
How old was her son at that time, did you say?
A small child, a very small child, under a year maybe or less. I think he was just sitting up at the time, if my memory serves me correctly. I had brought some toys up to the home that my daughter no longer used, and I think I had given her some toys previously also.
So what happened then when you were at the house?
We had dinner, and what had happened was, it was late in the evening, and I had expected to go home that evening, and instead she said to stay, and they had from best of my recollection, they had a mattress they had a 3-room home, and they had a mattress in one room, and I thought I was going to put the mattress down. I mean, it may sound a little bit naive, but I thought I was going to sleep in that room. But
what happened next?
Well, Julie asked me to sleep with her.
So you and Julie had made love that night?
Yes.
Okay. And that was on a Friday or Saturday night? Which was
it? It was Friday, and I was there the whole weekend.
So you were Friday, Saturday, and Sunday?
Yes, sir.
When did you leave?
Sunday night.
Okay. Did you ever have sexual relations with Julie Jensen again after that weekend?
To the best of my recollection, no, sir.
Did your relationship with her continue after that weekend?
No, again, to the best of my recollection, it ended after that.
Do you know how it ended?
She told me not to contact her anymore. You know, she kind of prepared me one way or the other as far as if she had decided to, you know, stay and try to make her marriage work.
What do you mean one way or another? I don't understand. What did she do to try to prepare you?
She asked me, she asked me to promise never to talk about that weekend.
With you or with anybody else? Or
Anybody else.
And, okay, she asked you never to talk to anybody else about it. How does that relate to if she was preparing you for the end of the relationship? I don't
Well,
understand.
in recollection, I was. She asked me never to talk to anybody about, and I didn't think of it at the time. I don't. It was a sudden where she just said, "This is no more. I'm staying with Mark."
So she told you she was not going to have a relationship with you. She was staying with Mark.
Yes.
Now, when did that conversation occur in relation to that weekend?
That was like maybe a day or two afterwards, I think, to the best of my recollection. Or maybe a week, somewhere in that time frame.
So it was within a week after that you spent the weekend. She said that she didn't want you to talk about this and that she was going to stay with her husband.
Yes.
And did you accept that?
Yes, sir.
Well, at one point you wrote a letter, did you not?
Yes, I did.
I show this document is marked as States Exhibit S201, and I ask you if you can identify that document.
It was something that I had sent her.
And it was sent to care of Jill Griffin.
That's correct.
So it wasn't sent to Julie's address, it was sent to Julie's sister-in-law's address.
Correct.
Now, how much time elapsed between the point where Julie had told you to never speak of this weekend and that she's going back to her husband and the point where you sent her that letter?
It must have been, having reread the letter, the best of my recollection would be it would be maybe 6-7 months, according to that.
So it was about 6 or 7 months after she terminated this relationship with you that you sent this letter to Julie Jensen.
Yes.
Now, at some point, you had been interviewed by a police officer with the Village of Pleasant Prairie, correct?
To the best of my recollection, the interview was after they had received this letter.
Now, had you made any phone calls or any phone calls, whatever, to the Jensen, the residents of Mark and Julie Jensen?
No.
You never made any phone calls to that resident?
Did you say hang-up calls, sir?
Any hang-up phone calls?
No, sir.
After Julie had asked you to not speak of that weekend and told you that she wanted to continue her relationship with her husband, did you ever try to contact her via telephone?
No, sir.
Did you ever leave any photographs of any sort around that house in the ensuing years?
Absolutely not.
Did you engage in any course of harassing or abusive conduct toward Mark or Julie Jensen in the years after Julie had told you she wanted to terminate that relationship?
Absolutely not.
Aside from this letter that was mailed, you say, about 6 months after Julie had told you she wanted the relationship over, did you have any other contact with Julie or Mark Jensen whatsoever?
No.
Now, At the time that this relationship had commenced, you and Julie were still working at the same place, is that correct?
That is correct.
Did she continue to work there after she terminated the relationship?
No.
How much time after she terminated the relationship did she leave that place of employment?
It was immediately. I didn't even know, I wasn't aware that she had resigned or anything. She just didn't show up, and I didn't ask.
After that weekend, after that time when Julie told you that she wished to terminate the relationship and continue her relationship with her husband, did you ever see or speak to Julie Jensen ever again after that point?
No.
Did you feel that you were in love with Julie Jensen?
Yes.
Do you still love her today?
Objection to relevance.
Well, during the years following the point where she told you that she wanted to terminate the relationship, did you still love her then?
I have an extreme, when somebody tells you that, or rejects you, okay, you have to.
I think you answered the question which was asked.
If you could answer that question, did you continue to have strong feelings for Julie Jensen in the years following the point where she told you?
I feel very strongly about the Julie that I knew. Yes, I mean I would say I would say that yes, I loved her, and I would have helped her in any way if she needed help, and that's the reason why I wrote that letter, because there were allegations made about me.
How long did you continue to work at the company where you had been working at the time that you met Julie Jensen?
I believe it was 92 that I moved down. It was either end of 91 or 92 that I moved down to North Carolina to start to work in a joint venture between Dean Witter and Bank America. Dean Witter and Nations Bank, excuse me, Nations Bank.
So you moved to South Carolina or North Carolina?
North Carolina, sir.
And that was in when?
It was maybe 92. I'm not sure the exact timeline.
And how long did you remain in North Carolina?
It was 4 or 5 years. I think I came back to Illinois, I believe in 97.
And when you moved back to Illinois in 97, where exactly in Illinois did you move to?
I moved to Wheeling, Illinois. I stayed with a sister.
And how far is Wheeling, Illinois from Kenosha, Wisconsin?
Half hour, 45 minutes.
So when you moved back to Wheeling, did you try to have contact or contact Julie Jensen?
Absolutely not.
While you were staying in North Carolina, did you ever have occasion to come back to Wisconsin or Illinois?
You asked did I ever go to Wisconsin? No. Did I come back to Illinois? Yes.
How often would you come back to Illinois?
It would be no more than probably 3 or 4 times a year. More than likely, it was twice. Once around the winter holidays and once in the summer to pick up my daughter to bring back with me to North Carolina.
So you had your daughter in the summers?
Sometimes, yes.
And during the holidays?
Sometimes.
Did you ever come back to, and where was your daughter living at that time? Where in Illinois?
Mount Prospect, Illinois.
And how far is Mount Prospect from Kenosha, Wisconsin?
I would imagine a good hour. I would think hour and 15 minutes. But if I may expand on that, I stayed usually with my parents in Niles, Illinois. So, again, you're talking about the same time frame.
And when you came back to pick up your daughter at any time, did you seek to have contact with Julie Jensen?
Absolutely not.
Did you seek to make any phone calls to the Jensen residence?
No.
Did you ever leave photographs around the residence during that time you came back to pick up your daughter?
Pardon me?
Did you ever leave photographs around the Jensen residence when you came back to pick up your daughter?
Absolutely not.
Had you made any effort to keep track of where Mr. Jensen, Mark Jensen, was working or where he wasn't working during that time?
No, sir. No.
Did you ever leave a photograph around the Jensen residence or around the place where Mark Jensen worked with the writing on it, mine is bigger than his?
No, sir. Absolutely not.
Now, you were cited by the Pleasant Prairie Police Department for sending this letter, is that correct?
That is correct.
Tell us about that.
Well, I got a phone call one day from the detective, and the reason why I sent it, Julie had given me the names of her siblings, and she had talked about them very favorably. I mean, she loved her family. And that we had gotten, at least I thought, close, in that time frame. That the relationship was not about sex. I was looking. She looked like she would be she was, in my viewpoint, a wonderful person. And I'm sorry, could you read?
Well, tell us about the circumstances surrounding you receiving a citation for sending this letter.
Okay, so I had found out after, I think, 3 or 4 months that my boss had come to me and had said something regarding or something in passing, either that or the secretary. I don't know who. I don't remember who. And they had said something about some kind of pornography and harassing. And they had checked, and unbeknownst to me, because this was months later, they had checked my phone calls to see if they were coming from work and my work schedule. And I did have at the time, Dean Witter was part of the Sears group. So when I wasn't at the office and I didn't have my daughter, I was at the Sears store. So I had a full schedule, and basically I found out that they had checked the phone records, and they didn't find anything. That's how come they
Hearsay.
Move to strike.
Disregard the portion after they had checked my phone records.
So regardless of that.
Well, strike that statement too. They had checked my phone records. Go ahead.
Quite aside from that, what did you do next that induced you to write this letter?
Well, when I heard about that, I thought there was, first off, I wanted to let her know that it wasn't me doing any of the things, and secondly, I was concerned, that something was wrong, and I wanted to let her know that I wasn't doing it. That's what induced me to write the letter, and my concern for her well-being.
So this letter, in your view, is not a harassing letter?
No, sir.
Can you please read this letter to the jury? Because I can't really quite make it all out anyway. It's a photocopy, and maybe you can be present, I can't.
It's been 18 years, but I did get a copy earlier. Dearest Julie, I've had this card for over 2 months. I have debated whether to send it or not. Not because I have not wanted to, but because I did not want to upset you. Tim Notaro had a baby boy. Mother and baby are doing well. Jessica was in the office and went looking for you. She was disappointed when you were not here.
Judge, I am going to object. This is a two and a half page letter, and I don't think it has sufficient relevance to read the entire letter.
May I see it, please? Let's do this. Let's take a break at this point, and please don't talk about the case during the break. What's up? Well, let me just say that I read this letter as much as I could make out. There, I would say, are 5 to 6 lines that did not photocopy sufficiently well for me to read them, and I am inclined to sustain the objection.
May I be heard?
Yes?
Okay. Here's why it's admissible. First of all, Your Honor, defense counsel, in the course of his cross-examination of Officer Ron Cosman, made specific mention of the letter and indicated that this witness was cited for disorderly conduct because he sent that letter. And I think the jury, and furthermore, this letter, the contents of this letter stands in stark and total contrast to the course of harassing and hateful behavior that's been described by Officer Cosman being directed against the Jensen family. So I believe that the contents of that letter are relevant and admissible for those purposes. It would indicate that Mr. Tarica is not a person who was of a mind to do the things that defense counsel is alleging that he did.
Do you want to respond?
I think the court has had enough stalking cases to know that oftentimes stalkers take on a very pleasant tone, so I don't think it really would support that. But it doesn't have any admissible purpose. We're not here trying the harassment case for which he was already cited.
What was the outcome of the harassment case? Was a forfeiture
I believe he still has a warrant out for his arrest.
for his arrest?
I don't know. I don't know. I don't have any understanding of what happened. It was a municipal court case. It was not a criminal case.
Well, it would, if it were a criminal charge, then I would agree with you, Mr. Albee. It would be conclusive.
Well, but I still don't think we should spend time him defending himself, and the court will hear that the circumstances under which the letter was written. But I don't think he can. No more than anybody else, witness can say, "You want to hear something nice I did? Here's my letter. Aren't I a nice guy?"
That part I agree with. I was responding to the issue about whether or not it's conclusive. There's no adjudication, and on top of that, it's not a criminal conviction. So if he had been convicted of a misdemeanor as a result of this, then I would not hear his explanation.
I don't think the content of the letter is necessary for him to give that. In fact, he's already given his explanation. I didn't believe he was harassing, and I don't think the content matters. It's the fact of him contacting her after she asked.
There's much more than I want to hear. That I just don't think it serves a purpose. He's talking about other people in the office and how people react to working with their children and so on and so forth. I don't see it, Mr. Jambois.
And that's the whole point, Your Honor. The whole point is to show this jury the nature of this communication, that it was not harassing, it was not insulting, it was not demeaning. There was nothing in there about how mine is bigger than his or anything like that.
You should have objected when the business came up about his being cited for harassment, because that would have been irrelevant, and you didn't. And I'm not going to let you now explain it away by offering this extensive document that has nothing to do with this case.
Well, I can ask him about it. I just can't have him read it then?
Well, you could ask him some things about him, but nothing that'll cause me to lose any more hair. Don't say anything more.
I don't think I'm contributing to hair loss, Judge. You can't put that on me.
All right. All right, anything else?
No, that'll do it.
Okay. Ask the jurors to come in, please.
Please be seated.
The objection has been sustained.
So, Mr. Tarica, that letter that you wrote to Julie Jensen was an expression of your friendship for her?
Yes.
How did you close the letter out?
I added a PS to it, or before that I closed it, wishing you the happiness you deserve. I consider your friend. And then PS, friends are always friends, and friends in need is a friend indeed. You can always count on me.
And you had your return address, your name and return address on the envelope, is that correct?
I don't know, sir, because there is no, oh yeah, there is, I'm sorry. I do, my return address is on there, yes.
No, there's nothing in that letter where you said anything like mine is bigger than his?
Objection. Argumentative, relevant.
Judge, did you get the objection?
Yes, I'm thinking about it.
Okay, I didn't know what you were saying, sorry.
I wish I had it. Oral.
That means you can answer the question, sir. Do you remember what the question was?
Yes, absolutely not.
Did you ever, during the course of your short relationship with Julie Jensen, expect her to describe any previous lovers she'd had and compare their penis size to yours?
Objection, Judge. That's argumentative.
Sustained.
May I be heard, Your Honor?
No.
Okay. Were there any photographs that you ever sent to Julie Jensen with the words on them, is his bigger than mine? Or mine is bigger than his?
Absolutely not.
Nothing further.
Mr. Alden?
Mr. Tarica, on January 8th, 1992, you received a telephone call from an Officer Hunter of the Pleasant Prairie Police Department, correct?
I couldn't say yes or no as far as the date, sir.
Would it help you to review Officer Hunter's police report?
I would imagine.
Would that refresh your recollection?
Judge brings his dog in here?
Mr. Tarica, I'm showing you Exhibit 203. I'd ask you to look, actually, it turns out to be a highlighted portion, and if you could just read the few lines around both sides of that highlighted portion and let me know. It's on page 2, counsel. And let me know if that refreshes your recollection as to when you spoke with Officer Hunter. Just those few lines around the highlighted portion is all I'm asking you to read.
Okay.
Did you speak with him on January 8th, 1992?
I don't remember it, but his report says he did.
Do you have any reason to dispute that it was January 8th, 1992?
Objection, Your Honor. The witness has expressed that he has no recollection of it. And the writing has not refreshed his recollection.
Officer Hunter will be a witness in this case, Judge.
I'm sorry, I had gotten a note and I was, what was the question?
Actually, if I could have it read back, I'm sorry.
Question, do you have any reason to dispute that it's January 8, 1992?
Well, you're asking him to rely on a hearsay report.
And as I was saying, Officer Hunter will be a witness in this case and establish that date, I would imagine.
And in any event, what difference does that make, Your Honor? This witness was asked to read a document to see if it refreshes recollection. He read it, it doesn't.
Yeah, I think
Seems like the end of the discussion.
The witness appearing later in the trial has been a recognized exception thus far, but
Well, I think, no, actually, the predicate upon which the question is asked is whether or not this refreshed his recollection, and the answer was that it has not.
I understand. I was just trying to make things easier since we will have this evidence. But I understand.
But you're suggesting that the court has been inconsistent in rulings, and I don't believe that's true.
Mr. Tarica, you spoke with an Officer Hunter, though. You do remember that, right?
I spoke with an officer. I don't know if it was Officer Hunter or not, sir.
He called you at your work, right?
I don't remember that, sir, as far as recollection.
He told you that you had a conversation with an officer from the Pleasant Prairie Police Department in which he told you he was investigating harassment of the Jensens, correct?
I had a conversation once. I don't recollect when it was, sir, and who the officer was.
Okay. You had a conversation with an officer in which he told you he was investigating harassment, right?
I don't remember him saying harassment, sir. I remember there was a conversation, okay, at some point in time, sir.
What was said in the conversation, Mr. Tarica?
I do not remember, sir. All I know is that I did not do any harassment.
I didn't ask you that.
Okay?
I asked you what was said in the conversation.
I
if you
don't
recall.
remember, sir.
Did the officer, do you recall the officer saying to you that if you were calling Julie Jensen, that you should just stop, and if you had not been calling, then fine? Do you recall him saying anything like that?
I don't remember that, sir.
Do you recall telling Officer Hunter or the officer that you spoke with from Pleasant Prairie Police Department, let me tell you something, mister, and then you explained that you had had an affair with Julie Jensen? Did you say those words to the police
I
officer?
don't know. I don't believe so, sir.
You don't believe you said, let me tell you something, mister?
Sir, I don't remember that conversation.
Did you tell the officer that you had had an affair with Julie Jensen?
I don't remember that conversation, sir.
Did you tell the officer that when Julie Jensen's husband found out about the affair you were having with her, she broke up with you?
I don't remember that conversation, sir. I don't remember saying that.
Did you tell the officer that after she broke up with you, you accepted it and that you had not called her, nor have you made any attempt to contact her?
That would sound like my words as far as that, but I don't remember saying that. I don't remember that conversation.
Did you tell the officer that you were sick and tired of being harassed?
I don't remember this conversation.
Objection, Your Honor. I request that under the doctrine of completeness that the preceding statement be read.
May I see?
Judge, I'm not reading a statement. I'm just asking this witness questions about if he recalls things.
You're right. The objection's overruled.
Well, Your Honor, he was asking
He's
about-
asking him questions on cross-examination, and he can do it. Now, the objection's overruled.
Did you tell the officer that you had respected Julie Jensen's wishes to no longer contact her or to call her?
Sir, I don't remember this conversation.
Do you recall that 2 days before having a conversation with the police officer, you had mailed this letter that Mr. Jamboys was discussing with you?
I don't know if it was 2 days before, sir, but there was a date on the envelope. And I sent the letter.
The date on the envelope is January 6th, 1992, right?
It looks like the 6th, sir.
Did you deny to the Pleasant Prairie Police Department officer that you had had any contact with Julie Jensen while knowing that 2 days earlier you had sent a letter to her?
Your definition of contact, sir, that was it. I had not called her, nor had I seen her. I sent a letter in care of her sister-in-law.
Did you tell the officer that you had sent a letter?
I don't remember, sir.
Did you tell the officer that you had not contacted her?
I don't remember the conversation, sir, okay? But again, it was the definition of contact. I had not seen Julie, nor had I talked to her.
No, well, if you don't remember well, I'm sorry, go
Okay.
ahead.
Judge raises a good point. You don't remember
I
the
didn't say that.
How do you know what you may have said to the officer regarding this letter?
I don't, sir.
And do you deny that you would you have told the officer that you hadn't contacted her if you had sent a letter 2 days earlier?
I would have to say the definition of contact. With the letter, I wouldn't have thought it'd be a contact.
And
But I am unsure as far as that conversation.
well, now you can remember 15 years ago that isn't how you would have defined contact when a police officer was asking you if you'd had contact with Julie Jensen?
My definition of contact is to talk or see the person, sir.
And you wouldn't have thought to tell the officer, well, I sent a letter 2 days ago?
I don't think I would have said anything to him, sir. But that is conjecture on my part. I am not certain.
Did you tell the officer over and over that your feelings for Julie Jensen were over?
Don't know, sir.
Did you tell the officer that you would never contact her again?
Pardon me?
Did you tell the officer you would never contact her again?
Did I never contact her again? Contacted her, or
Did
You would never, is that what you said?
Yes,
that I would never contact her again?
correct.
Again, I go back to I had not spoken with her, nor had I seen her.
No, that wasn't the question.
I guess I sent her the letter. There's January 6th, the postmark.
Did you tell the officer that you would not contact her again?
I don't remember that. I don't remember that conversation, sir. I don't.
Mr. Tarica, do you remember the police officer calling you back 6 days later on January 14th, 1992?
I remember, sir, there was one, from my recollection, I only talked to a police officer once that time, and it was after the letter was sent.
Do you recall the officer calling you and saying, how could you tell me that you had not contacted her when you sent a letter 2 days before I contacted you?
Absolutely not, sir. Absolutely not. I don't remember that.
So you're saying that officer never told you that?
I believe I would have remembered something like that, sir.
Well, you recall getting a ticket for harassment, right?
I got a citation in the mail, yes.
And the officer told you he was citing you because he had talked to you beforehand and you denied any effort at contacting Julie Jensen, right?
Sir, to the best of my recollection, the first phone call, the first contact did not exist. It was just the second contact with that police officer. That is to the best of my recollection. That first contact, I don't remember, nor do I think it took place. I don't remember it.
So you think that the officer falsified his earlier conversation with you?
Sir,
It calls for speculation on part of this witness as to what another witness did.
If the officer says he talked to you, is that true?
Objection, Your Honor. One witness does not comment on whether another witness is telling the truth.
Is that your question? If it's accurate?
He said true, he didn't say accurate.
Well, rephrase your question.
If the officer said that he talked to you, is that accurate? Talked to you the first time?
sir, I just remember the conversation after the letter.
At that time, do you recall the officer telling you he was sending you the citation?
What I remember, sir, he asked me for my social security number. He did not tell me he was sending me a citation, to the best of my recollection. It was a surprise when I received it in the mail.
Did you tell the officer that you were still madly in love with Julie Jensen?
Sir, I don't remember the conversation.
So you don't recall if you told him that you were still madly in love with her?
No, sir.
Asked and answered.
Overruled.
You did receive that citation in the mail?
Yes, sir.
You've never paid it?
No, sir.
Are you aware whether there's a warrant out for your arrest relating to that citation?
From what I understand, there was a warrant, but supposedly it was going to be quashed, I believe.
How did you hear that?
Well, I had told the district attorney that, from the best of my recollection, there was a warrant for my arrest or whatever.
And the district attorney was going to quash that warrant if you came up to testify?
No, sir. I was worried that if I came up to testify, that I'd be arrested.
Which is what happens when people have warrants out for them.
Well, that's the chance I took, sir.
Well, I'm trying to understand if you were taking a chance or were you told that you would not be arrested for an outstanding warrant that you have not paid in 15 years?
There was no promise, if that's what you're looking for, sir.
Well, why is it that you're here not expecting to be arrested on an outstanding warrant?
I said, sir, earlier that that's a chance I took.
What were you told with respect to whether or not?
I told them I thought there was a warrant still outstanding for.
What were you told?
They said they'd look into it, and it would be taken care of.
Thank you, Judge. Have you been told that it has been taken care of?
No.
But that's your understanding?
Sir, I don't know.
Mr. Tarica, can you give me some idea of when you and Julie Jensen began getting close?
I don't have a timeline for you, sir.
You said that you had contacts with her and her son, David.
Yes, sir.
She didn't bring David to work with her on a regular basis, right?
She brought David down to the office, I believe, once or twice.
But that isn't the basis on which you observed her parenting skills that you were testifying about, right?
It was the weekend that I spent with them.
The weekend that you spent in Mr. and Mrs. Jensen's house in Pleasant Prairie?
That is correct.
Did she bring David over to your home?
I don't believe so, sir. To the best of my recollection.
She was at your apartment?
I believe she was at my apartment once.
How long before you had sex with her in Pleasant Prairie was that meeting in your apartment?
I don't have a timeline for you, sir.
Was it a week? Was it a month? Was it 6 months? What was it, Mr. Tarica?
I'm sorry, sir. I can't give you a timeline. I don't remember.
Could it have been less than a month?
Sir, it would be speculation on my part.
What happened in your apartment?
Nothing, sir.
Was there any fooling around?
No, sir.
You said that she went with you to your divorce lawyer?
That's correct, sir.
Were you married at the time?
I was in the process of a divorce.
Does that mean you were married at the time?
Yes.
When does the date of your own divorce give you some idea of when you began your relationship with Mrs. Jensen?
The end of the divorce, you're saying?
Well, do you know what date you were divorced?
No, sir.
Do you know what year it was, Mr. Tarica?
I believe it was 1990.
That your divorce became final?
I believe it was in 1990.
So your relationship with Mrs. Jensen began in 1990?
We were friends, sir. It might have been in 1990. It was just before the end of my divorce, I believe.
Well, you were friends, but you were making plans to meet before work started, right?
It was not. We did not meet every day, sir.
Now, how many days a week did you meet before work, Mr. Tarica?
It was not. Let me see. To the best of my recollection, maybe once or twice a week for 10 minutes before work started.
For how many weeks?
I don't know, sir.
Did you have play dates with your daughter and her son?
Yes, at another person's house, yes. One or two, from my best of my recollection.
You had one or two play dates?
Yeah,
Who was
yes.
the other person?
The other person was the administrative secretary in the office.
Did that person also have a child?
Yes, two.
Would you also go out to eat with Mrs. Jensen?
We would have maybe lunch in the cafeteria, but I think that was it.
What other times did you see her outside of work?
Very seldom, sir. There was not a lot of time.
How
Very
many,
seldom.
Mr. Tarica?
I would say if it was a handful, that was a lot.
I don't know what a handful means.
At the most, 5.
Does that include the entire weekend that you spent at the Jensen home in Pleasant Prairie?
Are you talking days or times, sir?
But that's what I'm trying to find out from you. You said no more than 5 times, and so I'm trying to figure out if you're counting Pleasant Prairie and how many times Pleasant Prairie counts.
I would, so let me see. Outside of work, I would probably say about 5 or 6 times.
And I'm trying to figure out, does Pleasant Prairie count in those 5 times? Or 5 times apart from that weekend that you spent?
I would count that weekend.
Does that count as 1?
1, sir.
You arrived on Friday evening at Mrs. Jensen's home.
Yes,
You knew she was married.
yes,
You knew her husband was out of town on a business trip.
yes,
Her son was there the whole weekend.
yes,
And you were having sex in her and her husband's bed, right?
yes,
On Friday,
yes,
on Saturday,
yes,
on Sunday.
no.
and her son was in the next room.
Sleeping, sir.
Mrs. Jensen filed for divorce in 1991. You're aware of that, right?
No, sir.
You're telling me you're unaware that she filed for divorce that year?
Sir, I said no.
Did you have discussions with Julie Jensen about her getting a divorce?
I brought her to my divorce attorney.
Was that for the purpose of her investigating getting a divorce?
Yes,
You were trying to assist her in getting a divorce?
would you define assist?
She told you, did she tell you she was interested in getting a divorce?
Julie was very unhappy.
That's not my question,
Okay.
sir.
You know,
She
this
was
is
in-
taking much longer than it needs to. Please listen carefully to the question and answer what's asked.
Okay.
Did she tell you she was interested in getting a divorce?
Yes,
Did you say, I can help you, I'll take you to my divorce lawyer?
I don't believe I said I can help you. I'll take you to my divorce attorney.
How is it that she came to go to your divorce lawyer with you?
She knew I was going down one time, and I asked if she wanted to come with and talk to him. But there was no way where I said I would assist her.
But you knew you were assisting her by taking her to your divorce lawyer. That was the purpose, so she could talk to him about the possibility of getting a divorce, correct?
She didn't. Let me. Okay, I'm trying to.
Yes or no?
I guess she was looking at the possibility of a divorce.
When was it that your relationship with Mrs. Jensen ended?
I don't know the date, sir.
How old was her son at the time?
I would think somewhere, give or take months, several months, probably around 1 year old.
And is that how old he was when you were having sex that weekend in the home?
He was in a, I can remember the child was, I believe, sitting up and could play with blocks and play. As far as the exact age, I'm not sure what age David was, how many months he was.
Do you have any objection to this certified copy?
I've got no objection to that, but I don't know how he's going to.
It's a certified copy, so I'm just...
Yeah, I don't have a problem.
Judge, I'm moving in Defendant's Exhibit 2004, which is a certified copy.
204?
204.
Oh, please.
What's that? Which is a certified copy of the divorce proceedings that were initiated by a petition filed by Julie Jensen on June 24th, 1991, and ultimately dismissed.
This is the entire file.
That's certainly my understanding, Judge.
All right. Any objection?
No, Your Honor.
It will be received.
Is your best guess, Mr. Tarica, that your relationship with Mrs. Jensen was in late 1990 and early 1991?
I don't want to guess, sir.
And if it assists you, that divorce petition indicates that David Jensen was born in January of 1990.
Sir, I again,
The weekend that you stayed That weekend that you stayed at the Jensen's house, was it winter time, spring, fall?
It was winter time. It was cold out. It was cold out.
After you quit work, did you come up to the Jensen home?
Yes.
And that was after the weekend you had spent there, right? No?
Sir, I don't know what, I apologize. I lost the train you were going on.
At the time that you spent the weekend at the Jensen home, having your affair with Mrs. Jensen, you were still working at the same place, right?
We were working at Dean Witter, sir.
And that's the same place, right? You both worked at the same place then, correct?
Yes.
When did you quit that job?
92 maybe? I'm not sure, the timeline, sir.
And after you quit that job, did you ever come up to spend time at the Jensen home with Julie during the day?
Sir, I transferred from Dean Witter down to a joint venture firm with Nations Bank. Okay, it was a transfer. Secondly, as I explained earlier, okay, after that.
Mr. Tarica,
Yes.
perhaps you could just answer that question with no, if that's the answer. All I'm asking is, after you quit work, did you ever come up and spend time with Julie Jensen in their home during the day?
No.
It's your testimony that you were never at the house after that weekend that you spent together.
To the best of my recollection, I wasn't there.
So is that a maybe?
I had seen her once outside at one of the malls up in Kenosha. But I don't recollect being back at that home after that weekend.
Were you aware of Julie Jensen doing daycare after she left Dean Witter?
No, sir.
Were you aware that in 1990 and 1991, Julie Jensen was seeing a counselor?
What kind of counselor, sir?
Were you aware of her seeing any kind of counselor,
No.
sir?
No.
You're still a stockbroker?
Yes, sir.
You're familiar with stock symbols?
Yes, some.
I mean, company symbols?
Some.
Companies use abbreviations for stock exchange purposes?
Yes.
Fair to say? Okay. I'd invite your attention to the screen behind you. I'm going to show you Exhibit 174. And let me zoom in a little bit. You see that it says oils,
Yes.
and then it says PDE.
Yes.
And do you know PDE to be abbreviation for Pride Petroleum?
Yes.
And NE, you know that to be the abbreviation for Noble Drilling?
Unaware of that one, sir.
Okay. Do you know what NE might stand for, or is that just one you don't know?
That's just what I haven't memorized.
Okay. DD, is that DuPont?
Yes.
HI is Household International? You don't know that one?
Right.
Okay. McD, McDonald's?
Yes.
MCK McKesson?
I would imagine it is, but it's not one that if I could say it was.
Okay. And I know you weren't expecting the quiz on stock symbols today, but you do recognize at least the PDE is Pride Petroleum, a gas company, right?
Yes.
And oils, OILS, do you understand, is that for any company as far as you know, or is that sometimes short for petroleum companies?
Oils is oils, sir. I mean, oil companies, I would imagine.
Okay. Let me show you Exhibit 184. We have again oils. You recognize PDE again as Pride Petroleum, true?
Correct?
GLM is Global Marine.
Yes.
I think we have NE again. You don't recognize that. And SLB, is that Schlumberger?
Yes.
Let's show you one. One more. This is Exhibit 195. Sir, and GPS, that's the Gap. Is that right?
I would imagine.
And BSX is Boston Scientific.
That I do know.
I'm sorry, you don't know that one?
No, I do know that one, sir.
Yeah, oh, okay. And that is Boston Scientific, true?
Yes, that's correct.
Julie Jensen, you were aware, had a Series 7 broker's license?
She was a registered assistant, yes.
And I'm sorry, does that mean she
She could place an order for a broker.
She could place stock orders?
As a sales assistant, she didn't initiate the trades, but if the broker wasn't in, she could accept them.
The broker could give her the instructions and she'd be qualified to, based on her licensing, to place the order?
She could write the ticket.
Okay. Did Julie Jensen ever tell you that she was suffering from depression in 1990 or 1991?
No.
One of the items that you sent to her with your letter was a story about adult children of alcoholics, correct?
That is correct.
She had discussed with you her mother's history of alcoholism?
She had touched on it briefly.
Briefly enough that you felt it appropriate to send her an article about adult children of alcoholics.
Yes.
You sent this letter to Jill Griffin?
Correct.
That's her sister-in-law?
Yes, I believe so.
Had you met her before?
No.
How is it that you knew that Jill was her sister-in-law and that it would be appropriate to send her a letter?
Julie gave me a list of her siblings. And obviously, I find out after the fact it was inappropriate.
And you sent her a newspaper article about sort of bemoaning the fate of nice guys, correct?
Correct.
And you felt you were a nice guy?
Yes.
In your dealings with Julie Jensen?
In my dealings with everybody, sir.
And you felt you were being a nice guy, having an affair with a married woman and having sex in her home with her young child in the next room?
Julie was very unhappy. She was thinking of getting
Answer the
into...
question, please. Yes or no? Well, it's argumentative, really.
Okay.
Your Honor, I don't mean to...
That's all I have.
Any question?
Nothing further, Your Honor.
You may sit down, sir. Well, folks, we'll start at the usual time tomorrow, and let me ask that you not read, speak, listen to, or watch any account of the trial, and don't speak with anyone, nor listen to anyone else speaking about the trial or any aspect of it. And I told you it was going to get warmer. And it's up to 8 degrees, I understand. So enjoy the evening.
Please all rise.
But twice now in the...
On record?
Yes. Twice now in the last couple of days, Mr. Albee, you've made statements about the court making inconsistent rulings. And you're welcome to make a record on that now as to what you claim was inconsistent in the rulings which were made.
No, and Judge, the comment today, I guess I probably should have been quiet on that one, but it really, the court on several occasions has inquired, and for all I know, it may have been on some occasion when I was questioning a witness too, but on several occasions the court has inquired in response to a hearsay objection, well, will that witness be testifying? That is, that whoever the declarant is, the court has inquired whether that witness would be testifying later on.
Well, and in some cases that does have something to do with it, but this actually was a case where you were asking the witness to refresh the witness's recollection, and the witness said it didn't refresh the witness's recollection. So hearsay had really nothing to do with it, did it?
No, but I understand, and I understand the court's ruling clearly was right on that point because it hadn't refreshed his recollection. But I was just looking for a little bit more open attitude on that issue, so I wouldn't have to, so that I have the date because it's going to come in through Officer Hunter.
It may, but I don't want you to be making comments like that unless, you know, you're welcome always to make a record if you think there's error being committed or if you think you're being denied a fair hearing on something, but I don't want you to be making commenting on the ruling of the court without good cause.
I apologize. That's not my intent. I really was trying to just sort of remind the court that there's been a little bit more lenient attitude on if there's a witness coming later on.
But that wasn't the issue here.
I recognize that it wasn't the precise issue, but I thought the basis...
Precision is the name of the game.
It's different.
Not this stuff that's been coming in here, these statements about improper bolstering and something, and you've got to talk with the rules. There are rules. We have a statutory evidence code, and you have been very good about that in some respects when you've talked about when you've given the numbers and the like, and that's fine. Then I know what you're talking about, but making these amorphous objections that the lawyers loosely throw around, which don't have a basis in the code, I don't want to hear them anymore.
Well, Judge, I've said 90403 a number of times, and that really didn't meet with the court's approval either because that was just a catch-all, but I think it's appropriate as to why a lot of this evidence should have come in. Improper bolstering, I think, is a reasonable objection. A lot of times it's because the prosecutor is giving his opinion. That is a basis for reversible error in terms of him bolstering the witness by vouching for him through his question. So I think it is often an appropriate objection, and it's been recognized as a basis for reversing convictions.
I'm not going to say there isn't a proper objection under certain circumstances, but it's just been thrown around rather loosely. But anyway, the bottom line is, and I don't want to get an extended discussion, I certainly don't mean to suggest at any time you've been disrespectful or that your conduct hasn't been exemplary during this trial, but I do want you to understand that we can't have a situation where there's loose comments being made like this by either side. Is that clear?
It is, Judge.
Thank you. And what's on the agenda tomorrow?
More witnesses. And as to which ones, well, tomorrow's Friday, correct? I believe Chris Long is going to be back tomorrow, and possibly Dr. Mainland. Bernard Bush has been waiting around in the county jail here for a long time to testify, so maybe we'll get to Bernard Bush. anything, anybody else? Is that?
Well, let's talk about Dr. Long. Now, I want the record to be clear on this. There's no lingering ruling out there that hasn't been decided. I have stated I'm not going to allow examination on Dr.
With respect to
Long with respect to his failure to exercise a proper degree of care in the Stallings case. I've stated I'm going to allow evidence on the issue of doctors, whether he's in some way trying to protect his reputation, and I've also stated I'd allow questioning on whether or not he has given deceptive answers in a prior case, including the Stallings case. And those were the rulings that were made, and it was only put over so that you could familiarize yourself with the 1,000-page transcript to which Mr. Albee was making reference.
That isn't entirely my understanding, Judge.
Nor mine, so.
All right, you tell me what you think I left.
My understanding.
No, let Mr. Albee go first, and then I'll hear you.
The court will recall that when we came to a close with Dr. Long, I was in the midst of conducting the examination outside the presence of the jury to make the offer of proof as to what he would have to say. We did not complete that. I think it's because it was the end of the day, and then at the end of the day, excuse me, Mr. Jamboys also asked for the transcript that I had, which has been provided and copied and returned. But we had not completed that portion of things, and I had understood that we'd be revisiting the issue after Dr. Long after we completed the examination of Dr. Long outside the presence of the jury.
And my understanding, Your Honor, was that there really hadn't, the one ruling that the court had made was that you were not going to be relitigating the Stallings case, and so we were not going to be getting into whether or not Dr. Long had committed some kind of an error with respect to his handling of the Stallings case. However, my understanding is you were allowing the defense attorney to inquire into Dr. Long's testimony regarding an exhibit, and it was Exhibit 15 in the criminal case. And the question was whether or not Dr. Long had altered an exhibit. And you were, at the time that we broke, it was my understanding that you were inclined to allow defense counsel to ask Dr. Long about that exhibit, whether or not he testified accurately regarding an exhibit in the criminal case. That was my understanding. And the testimony, if to refresh the court's recollection, is that there was something about whiting out some numbers on an exhibit. Okay, well, and my understanding is that you were allowed, that at the time that we broke, your inclination was to allow testimony, a cross-examination of Dr. Long on that one issue.
And now, on the issue of whether or not he had been under fire professionally for his conduct in the Stallings case, and whether he had also committed errors in this case and was testifying as he is here in the court only to protect his reputation. I think that's what I said. I agree with you that I had stated that I would not permit examination on Dr. Long's compliance with the standard of care expected of a toxicologist in a case in 1989.
Well, Your Honor, if you're going to allow defense counsel to cross-examine Dr. Long about whether or not he has received criticism from one court or another concerning his handling of the Stalling case, which is what it sounds like you're going to do, that's equivalent to opening not a barn door, but a door to an airport hangar. It's do you have any idea how much license you're giving opposing counsel here?
He's going to have to be careful. I understand there's some risk. There's no question about that. But look, if Dr.
case and to litigate it here.
No, well, your point is, I suppose, a good one, but Dr. Long acknowledged during the voir dire examination, as I recollect it, that you could say, I think he said something to the effect of, you could say that the exhibit, after he had altered it at the direction of the district attorney, it could be argued that it was deceptive. I think he acknowledged that, did he not?
No, what he said was that it was different, because the report that he had prepared.
Is there a possibility we can get TV people to help us with this?
Your Honor, I think you're supposed to get a transcript, but I could be, I have concerns.
Well, the reason the transcript might be more difficult, if they've got it right on hand, that they could locate it for us, it would be a lot easier than getting the transcript. I certainly would, the transcript would undoubtedly be preferred, but I don't know which reporter it was even that day.
I don't either. But you see, here's the thing, Your
Tell me
Honor.
it can't be done, apparently.
I'm indicating it's not here in this.
Physically?
We've sent ours out.
So, Your Honor, here's the concern that I have in terms, I mean, frankly, when I left the courtroom, it wasn't real clear to me what, and I'm not being critical of the court, but it wasn't real clear to me what the parameters were that we'd be looking at when we came back into court. But it was my impression that you were going to allow some measure of cross-examination about this exhibit. Now, if I was wrong in that regard, and really what the court's inclination was to allow cross-examination of Dr. Long about whether anybody had criticized him, anybody who's professional had criticized his handling the Stallings case, I'm telling you this, we're reopening the Stallings case.
Well,
we're going to have, and Dr. Long has brought with him, I believe, or will bring with him, boxes and boxes and boxes of information regarding the Stallings case. And so when we come back tomorrow morning, let's re-advise the jury, this is not going to be an 8-week case, more like 12 or 14 weeks, because now we're going to be relitigating whether...
We are not going to relitigate the Stallings case. I've made that very clear, I'm sure.
Well, you did say that, but
Okay.
then you just got done saying...
Just a minute. No, wait a minute.
Okay.
As you know, under the rule of 90608, the witness, or Mr. Albee has to take the witness's answer. He's not going to be allowed to impeach him with extrinsic evidence. So he can ask carefully tailored questions about whether or not he's been under some fire professionally, for example, for his conduct in the Stallings case. And I'm not talking about the scientific content. I'm talking about if I know that he gave an answer. One way or another, I guess we need to see, or in print or on video or audio, what Doctor acknowledged during that short voir dire examination. But it was my recollection he acknowledged it. I certainly was left with the conclusion that he was acknowledging that he had done some things that he oughtn't have done, and he kind of shifted the blame onto the district attorney, but I think he did recognize ultimately he bore some responsibility.
You was talking about one exhibit, Your Honor.
Well, you know what? If you go in and you give some information to a jury that distorts the evidence, even in a small way, you don't think that's a big matter?
Your Honor, what I'm trying to get an understanding of is what the limitations are that will be placed on opposing counsel with respect to Dr. Long. So I don't know why you're yelling at me about this, because I still don't understand what the limitation is.
Well, you said it was just one exhibit, and I think, hey, one exhibit, it could make the difference.
So is the cross-examination going to be concerning that one exhibit? Or is it going to be concerning the piles and piles and piles of reports and documents and newspaper articles and television stories that have been done about this case?
And that point is perfectly legitimate, and let's hear what Mr. Albee has to say about it.
As I had previously indicated, I would not expect this to be a particularly lengthy examination. What I'd like to do is examine Dr. Long about the Stallings case, that he determined that there was ethylene glycol enrolling in Ryan Stallings' blood, that following that determination, Mrs. Stallings gave birth to another child while she was in jail awaiting trial, that child displayed the same...
I can see you're on a bad road already.
Well,
because you're trying to put in these facts that really almost do invite that we have to get into this.
well, if I could just finish, because it really isn't very long. It's...
Go ahead, but
While she was in jail, she gave birth birth to a second child who displayed some of the same symptoms that had been associated with ethylene glycol. The case went to trial. Dr. Long testified. Still was ethylene glycol in Ryan Stallings' blood. Ms. Stallings was convicted. She went to prison to begin serving a life sentence. It was determined that it was a genetic disorder that had caused Ryan Stallings' death, and that ethylene glycol had been, that propionic acid had been mistook for ethylene glycol. As a result, the prosecutor requested the judge to reopen the case. The judge did so, and the case was dismissed. And there's a lot of publicity about the conviction of this woman who had not killed her son, and Dr. Long suffered adverse reputation consequences as a result of that, and he now needs to protect his reputation in this case. Okay. And that's it.
Okay, well, that's about 90% more than what you're going to be allowed to put in your question.
Well, I do think that, I know the court has focused on 90608, but I think questions about how the witness conducted himself in that case goes to qualifications and are relevant and appropriate to examine. There were some other subjects, some of which I began and some of which I don't think I concluded.
No, we're not going to go through the science of it.
No, but here, these were things that I'd asked him. If the court will record, he mixed up nanograms and micrograms in a report. He said that he confirmed with mass spec a sample that he had not confirmed with mass spec. I think that's another very problematic area. There was a negative test on Ryan Stallings' blood for ethylene glycol, and he did not report that to the prosecutor. So I think that's what I recall offhand. I didn't know Dr. Long was coming back tomorrow, but I think those things are also go to qualifications and the integrity of his opinion in that case.
Okay. No, let me just say, you're introducing a lot of scientific questions, issues into your question, and creating the impression that there was something wrong with the science of it, and that we don't know. And we're not going to go through that for the reasons I've already indicated. The questions are being permitted as on the bias issue, which I think you have a legitimate quarrel with. But you know what? If he distorted an exhibit, and I'm a little hesitant to use that particular word because I don't think he's acknowledged that much, but let's use that word. If he created a deceptive exhibit, and you know, what difference does it make if it was a murder case involving a little boy and a mother getting sent to prison for life? If he altered an exhibit in a trial, in a court, in a small claims case, that's a serious matter, and it should be brought to, it's legitimate to bring it to the attention of the jury. But the nature of the case has got nothing to do with it.
And now we're back to where I understood we'd left off, which was that he wasn't going to be permitted to inquire into the Stallings case. He was not going to be permitted to inquire into whether there's been other things written about the Stallings case. He was going to be permitted to inquire into that one exhibit. That's my understanding of what the limitations were when we left the courtroom last time. And I'm not happy with that, but I can live with that because I believe that the witness can testify about that and we can explain it to the jury. That one exhibit, not the entire Stallings case. Not.
That's what was my impression.
Well, Judge, I just identified other problems. He said he confirmed a mass spec sample.
You can ask him about the things that did he? Let me start over. Did he tell the jury something that was inaccurate in that case, other than the exhibit?
Well, the court has on 90608 rightly recognized that I can ask him about I think I go to things that affect his reputation, and not 90608, but motive and bias. And the fact that that was a high-profile murder case is what makes him not want to be seen as making another huge mistake.
No, that has to do with whether it gets published or not. I mean, if he did it in a small claims case, they're probably not going to make a made-for-TV movie about it.
Right.
So that's got enough. His professional reputation is a professional reputation. If somebody wrote something in the New England Journal of Medicine about what an outrageous thing he did in a small claims case in St. Louis, Missouri, and if whoever makes the publication decisions in the journal decides to print it, his reputation is just as much under fire as if he does it in a murder case
Well, there are different ways.
CBS makes a movie about it.
There are different ways to show his motive and bias, and if I had the New England Journal of Medicine being highly critical of him, that would be one way that I would show. If I have the fact that this was a highly publicized case in which many people believe that the toxicology was screwed up.
Yeah, you're starting again with the many people. You told me about a doctor you talked to in Las Vegas, and I don't know if this conversation occurred in a crap table or a conference or what. What happens in Vegas stays in Vegas. Not what many people believe. That's why we're not going to retry the scientific case.
No, it's because it was a major case. It was well known, and I mean, I don't understand why. I have as much proof of this as he does that Kelly Jensen was intentionally lying in the forfeiture hearing. I mean, I don't have to prove with absolute certainty that he screwed up.
Different rules were applicable. Very different rules. We're back to the rules again, Mr.
I know, and motive is something I get to show. That's clear.
I've told you when he's objecting to it. I've told him you're going to be allowed to ask him questions about his motivation, but you're not going to be able to color them up with facts that create an impression with the jury that he sent some woman to prison for life with bad science. Maybe you are going to be able to create that impression that he did an injustice in a court by misrepresenting some facts. Maybe you'll be able to do that. But you're not going to be able to suggest that he did created a serious scientific error or made a serious scientific error that resulted in a woman being sent to prison for life when we don't have anything before us to establish that.
I would ask him about it. That's how we establish facts in the courtroom.
Well, we're not going to argue about this forever. I made the ruling I said last time. I remember distinctly saying we are not going to retry the Stallings case, period. And that's the end of that matter. I will permit your examination on whether or not he presented false evidence, or false again is the wrong word, deceptive evidence.
With respect to that exhibit. Exhibit 15.
In any respect, he says there's some other things. I don't know if he's back at the science or if he's back on misrepresenting facts.
And I want the witness voir dire on that outside the presence of the jury so the court can assess that, because I don't believe that's the case. I don't believe that it's going to be...
I'm afraid we're going to have to take the time to do that. What time is Doctor arriving?
I don't know, Your Honor.
But he's not number one on the griddle for tomorrow.
I think he is number one on the griddle, and he's arriving tonight, but I don't know what time.
Why don't you call Mr. Bush tomorrow in the morning? Oh, that's going to take forever too, I suppose.
Well, here's the thing. The question is, how does calling Dr. Long at a different time assist with the timing issue?
Oh, I suppose you're probably right.
I think either way, it's kind of a problematic point, and may as well just get him on the stand right away.
I suppose you're right.
And we'll try to keep it brief so that we can move on.
Yes. So let's start with a voir dire in the morning, and you're welcome, Mr. Albee, to put your questions as to anything that is examination on whether he's biased and is trying to protect his reputation, and whether he's in the past, and I say again that I'm giving you quite a bit of latitude by going back to a 20-year-old case, but I in that sense, I guess you are getting the benefit of the enormity of the matter, because and plus my intolerance for people who are deceptive in court. If you did it 20 years ago, you're under suspicion now, too. What?
It's 10 between the time he worked on that case and the time he worked in this case.
Well, the bottom line is I just don't have a whole lot of tolerance for people who don't come out with the truth in court.
And nor should you, Your Honor. And there's
Right.
there's nothing in the record that would suggest that here. Now, I will say this: if the court is allowing Dr. Long to be cross-examined or examined on this issue of that exhibit, I don't have a problem with that. But in terms of everything else that went on during the course of that case, do you
He mentioned two other things. What were the other two things, Mr. Albee?
Well,
He said he mass spectrograph, examine it with mass.
there was a sample of blood that he said, that his report said it was confirmed with the mass spec rather than just gas chromatography. That was not true. He wrote that it was confirmed. He wrote a report saying it was confirmed mass
Now, was he
spec.
asked about that last time when he was here?
I'd have to check.
You can ask about that on voir dire, but I'm telling you, if it's negligence, for example, it's not coming in front of the jury.
I'm sorry, what was that, Judge?
If it comes out, if he acknowledges that it occurred and it was due to negligence, then that's not coming in front of the jury.
Well, that's exactly what he's going to say. I know what he's going to say.
I don't know what he's going to say. Let's just finish what we're doing. What's the other thing?
Well, also reporting, he reported nanograms versus micrograms.
Once again, same thing. If it's negligence or if it's
I think
deceit.
that goes to his qualifications, is that he'd make a mistake and it would be reputation because he made that mistake.
You couldn't get any kind of an expert about any. Well, I don't want to say any because I can't eliminate everything. How many physicians have never made a mistake in their lives, Mr. Albee? How many dentists? How many lawyers? How many? We're human beings.
Right, and who hasn't made? And every single witness, what witness or what person has not had a bad memory or a mistaken memory or told a half truth or whatever? And you know what? That's what we ask them about all day long.
Because the rules say truth and veracity. It doesn't say anything about
They say
negligence.
qualifications of experts too. And this prosecutor bolstered his credentials by asking how many tests he does and all that kind of stuff to make it seem like, well, he must be really good. And so I get to point out issues that suggest that maybe he's not so good.
I don't disagree with you in many respects. You can, but and I think you've done a very good job so far, I might add. But we have our rules, and the rules say we're not going to retry the Stallings case. And truth and veracity is another issue altogether.
Thank you. Is that it then?
Actually, there was something else I was going to say, but I can't remember it, so I guess it will forever remain out of the caverns of my mind. What else today?
I can't think of anything else today, Judge.
Go ahead. I don't think anything, Judge, other than I'd like to get a handle on who the witnesses are for tomorrow.
Dr. Long?
It's
Mr.
Dr. Long, Bernard Bush, and Dr. Mainland.
Oh, okay.
And I think those three would. And if we run out of witnesses before we run out of time, we'll put Paul Ratzberg on the stand. But you know what? I'd bet my left arm that's not going to happen with those three witnesses.
I agree. Actually, there is something else I just remembered with Dr. Long, is I have not gotten to the portion of using the Mr. Jamboy's letter with him, and my understanding is I'm free to use that letter.
What do you mean you haven't gotten to the point? There was extensive cross-examination of that
I
issue.
had it on the screen and I had to take it off. I haven't gotten back to it.
What is your question that you're asking me right now?
Well, I just want to make sure we're settled on that. The statement by Mr. Jamboy's regarding what Dr. Long would testify to.
Oh, you're still in cross-examination mode.
Right, and I'm presenting that as evidence. The letter
With the large amount of...
Yes, right.
Yeah.
My letter to him.
Oh, that letter.
My letter to him
Okay.
is the letter he's talking about. He displayed it up there on the board, he cross-examined this witness about it. It was over my objection.
Right.
So I remember it pretty clearly, and now he's saying that he didn't do that.
No, I just played it, and then they were told to leave, and as they were walking out, you grabbed it and pulled it off the screen in the hopes that they hadn't really seen it entirely.
He wants to get it back on the screen
I
again.
get back. Well, I haven't really, I haven't done much with that because I've stopped. So anyway, just.
Oh, well, I guess we have to save something to argue about until tomorrow.
Well, I think we're clear on that. Yeah, thanks.
Enjoy the evening.
Thank you, Judge.
Thank you.